Good afternoon, everyone, and welcome to this panel 3, the remaking of international investment law, institutions and politics. My name is Nick Lawn. I'm a partner and head of arbitration at Bael and Bellis in London, in the London office. My practice focuses largely on investor-state arbitration, as well as commercial arbitration and public international law. I'm delighted to moderate this exciting panel today, looking at the remaking and rethinking of international investment law. The central theme of the global conference this year is rethinking global economic governance, a topic which is really inviting us to consider and question the future design of international economic relations. We've already had one roundtable discussion this morning on the future of international investment regulation. And our panel today really fits within this context in terms of discussing and interrogating the remaking and rethinking of international investment law. No one here is likely to be unaware of the growing calls for reform of the investor-state dispute settlement system. For some time now, there have been competing calls for reform, for retaining the status quo, for modifying the system, or even for abandoning the system altogether. Now, most of the reform agendas have been driven by specific institutions. Think, for example, of the EU's programme to overhaul and reform investment law, or ICSID's review of its rules and introduction of a new code of conduct for arbitrators. But there have also been global initiatives designed to address potential reform issues. And I'm thinking particularly of UNCITRAL Working Group 3, the process which began in 2017 and which plans to conclude its reforms by 2025. Yet significantly, most of these reform agendas, including the Working Group 3, have received only a mandate to address procedural issues and not substantive matters. Now, there are increasing questions as to whether such limitations were overly sensible. Now, there's no denying that the procedural criticisms of ISDS need to be considered. But it's arguable that this focus on the procedural, rather than on both procedural and substantive, results in critical gaps in the reform process. We may be missing an opportunity to reform. Now, our panel today is going to try not to be so short-sighted, and we're going to aim to investigate the issue of ISDS reform from a number of perspectives, including both procedural and substantive. In considering the remaking of international investment law, our panel is going to consider reforms from institutional and procedural reforms all the way through to the way that tribunals interpret underlying treaties and investment agreements. Now, the plan is to discuss 3 broad topics. Each topic will be introduced by one of the speakers, and then we'll have a follow-up discussion amongst the panelists, but also including, hopefully, members of the audience. Our first topic for discussion will be the tribunal versus permanent court dilemma. Now, Myriam's starting point is the backlash and legitimacy crisis currently facing ISDS and the proposed reform designed to tackle that issue. Drawing upon psychological and judicial literature in relation to adjudication in particular, Myriam is going to question and interrogate for us whether the proposed reforms on the table actually adequately address the criticisms which ISDS has been facing. Secondly, Javier will introduce a discussion as to whether something much more radical needs to be undertaken in terms of reform, whether we need to tear up the system indeed. His topic will be repoliticizing investment disputes. Is it time? Javier is going to start with the question as to whether the resolution of investor-state disputes should really ever have been taken out of the realm of diplomacy and put into the realm of law. He's going to investigate whether a state-to-state mechanism could or should provide a much more viable alternative to the current system of ISDS. Now, finally, the third topic for discussion will be introduced by Simon and Andrew, and they're going to address a much overlooked issue, namely the topic of silence in investment treaties. Simon and Andrew start with the observation that investment treaties are silent on many issues that frequently arise in practice. They're then going to address how arbitrators have typically approached this silence and whether the predominant approach, which they call the creative approach, is problematic. This again will then be set against the current proposals for reform, and we'll consider whether the current proposals actually solve this problem. Now, without further delay, let me introduce today's esteemed panel of experts. I'll introduce them in the order in which they will speak. So first up will be Myriam Gicquello. Myriam is a visiting lecturer at King's College London. She's also a PhD candidate. Prior to this, she worked in the legal department of a large multinational and completed all her legal education in France. Her doctoral research currently focuses on the role of psychology in legal reasoning and decision-making, and particularly how psychology influences the content and outcome of cases. Next up will be Dr. Javier Almeida. Dr. Olmedo is currently a lecturer at Queen Mary University, where he teaches on the International Dispute Resolution LLM. He's also manages at the same time as being an academic to fit in being an associate at Foley Hoag in their DC office. His practice, again, focuses largely on investor-state arbitration. Prior to his role at Queen Mary and at Foley Hoag, he undertook his PhD at the University of Luxembourg and was also a research fellow at the Max Planck Institute. Lastly, the last pair of speakers, Simon and Andrew. Now, Simon Batifort is the managing partner of the Brussels office of Curtis Mallet. His practice, again, focuses on investment treaty arbitration, includes international commercial arbitration and public international law. He joined Curtis in New York in 2011 and became a partner in 2019. He's just recently relocated to our side of the world, moving to Brussels in this year, 2021, to establish the new Brussels office for Curtis. He also manages to fit in being adjunct professor at Brooklyn Law School, as well as roles on within ASIL. Lastly, but not leastly, Andrew Larkin is an associate in the New York office of Curtis. He again concentrates on investor-state arbitration, international commercial dispute resolution, and other arbitration, again mainly representing states and state-owned entities. Before joining Curtis, he was a law clerk and also had a role at the ILC. So again, eminently qualified to introduce the topics under discussion today. Now, just before I hand over to the speakers, I'd like to emphasize that we're very keen for this to be an interactive discussion, and we very, very much would appreciate questions from the audience. So I would very much invite the audience members to use and utilize the public chat function to raise any issues, any burning questions that come up out of the speakers' presentations. And we will try to address those questions as they come up, but we will also have some time at the end to round up with some questions just to round up. One final last thing, just to note that the panel is being recorded and will be available for participants to review in the coming days. And I think in the coming weeks, it will also be available more generally on the internet. So just so everyone knows that. So without further ado, I shall hand over to Myriam to introduce the first topic for discussion.
Hi everyone, thank you very much for being here. So yes, so as Nick mentioned, in light of the criticism of arbitration and with the ongoing reform discussion, my paper basically uses psychology to question the effectiveness of a permanent investment court. So we all know that the institutionalization of ISDS will certainly address some of the shortcomings of the current system, but I argue that this is not a perfect alternative either. Indeed, courts still endorse the defects of human decision-making, since adjudicators, also being very intelligent, experts, and experienced in their domains, are still humans, and so therefore they have the psychology of judgment and decision-making impacting their decision without their conscious awareness most of the time. So this is why the paper argues that changing the current system of ad hoc arbitration without accounting for the psychology of judgments and decision-making will just leave one with the risk of repeating the same defects under a different forum. So to tackle this problem, what we have to do first is to incorporate psychology and understand which influences are likely to play out in this context, and then how we could potentially deal with these influences with some targeted intervention. And this is what the paper will do now. So first, we have to accept that we are all bounded in rationality, and so therefore we are limited in our cognition, and also our social environment will play a very important role in how we act and how we make our decision. And the same is also true for our motivation, and that's why the paper basically uses three perspectives, one cognitive, one motivational, and one social, to understand how arbitrators and judges really make their decision, how they arrive, or they come from different interpretation to then an harmonious decision. So if we start with the cognitive perspective, we have first confirmation bias and its associated phenomena. So the disconfirmation bias as well in the evaluation of argument, which means that basically one will respond favorably to information that is consistent with their prior belief, initial preferences, past experience, background, and knowledge, and on the other hand, will ignore or completely try to undermine information that goes against all these initial belief and preferences. And so we see that this strategy is in fact a natural one, because we all like consistency, coherence in our belief systems, and also we cannot, due to our cognitive limitation, attend to all information that is presented to us. And this has been demonstrated in the judicial system and also in our international arbitration, since this legal exercise has been characterized as a backward-looking exercise, a rationalization, where in fact you come up with the decision first and then you write the opinion later so as to fit the outcome. So have a reasoning that basically argues in favor of your preferred outcome. This is also happening because adjudication is such a task that we have to take our decision in a certain time frame. We have to be impartial, and also we have to provide justification, and all these factors do in fact promote confirmation bias. And this is problematic as a strategy. Also, it's quite useful. It has some shortcomings and some drawbacks. For example, we will be overconfident that the decision was the one that was warranted by all the evidence, while it was not. And also, the problem with the confirmation bias is also that some less than optimal outcome will still survive in the legal system, as we will have an illusion of validity. And in international arbitration, it's particularly problematic, because we all know that in the current system, we have party appointed arbitrator, and this is crucial for the parties, but still we can gather what could be the preferences of an arbitrator as regards the interpretation of a particular clause. And so therefore, if outcomes are determined by the preferences of arbitrators, then what is the point of having deliberations? So then this leads me to the motivational perspective in judicial and arbitral decision-making. So what do we mean by motivated reasoning? It means that the motivation of an individual will determine which cognitive processes they will use to reach a decision, whether they will use their intuition or whether they will really carefully attend to the information, so really deliberate on the information at hand. And so a motivation, to take Kunda's word, is any wish, desire, preferences that concerns the outcome of a given reasoning task. So quite simply, we have two types of motivation. We are either accuracy motivated, which means that we really want to arrive at an accurate conclusion, whatever this conclusion might be, or we could be directionally motivated, which means that basically we have one preference, we have one conclusion we really want to achieve, and we will achieve it at whatever cost. And so we can see from this that directional motives seem to promote information processing. And unfortunately, research has consistently shown that judges and arbitrators are not only driven by the need to make correct decisions, but instead they do have a variety of motives, some being personal, some social, reputational, and therefore their decision might not be driven by the need to have the best one given all the evidence at hand. And in fact, it has been demonstrated that giving good decision on the merits is not a particular incentive for appointment in international arbitration, and so therefore is not a determinant of arbitrators' behavior. In turn, this leaves room for directional motive alongside or in lieu of accuracy one to play some role. So then adjudicators being motivated with honor is not surprising, because we have also the time limit, as I mentioned, and the vagueness of the treaty provision makes the information quite ambiguous for arbitrators, which are all factors that promote motivated reasoning. And the same problems with cognition and confirmation bias. We do have the problem of overconfidence and of an illusion of validity. You are convinced that your decision came from a rational analysis of all information, and in fact, it was not the case. So then this leads me to the last perspective endorsed by the paper, which is the social perspective. Indeed, when we are a member of a group, we do not behave in the same way that if we were making a decision alone. And this is the whole point of social psychology and group decision making. And here, it has been used extensively in judicial settings. And so we see that, for example, the US Supreme Court, the justices there could in fact be strategic and basically decide according to the opinion of their fellow members sitting on the bench. It is the strategic model of judicial decision making. And we also have further evidence that courts and tribunals do have panel effects and polarization effect that we could not see with an individual taking a decision alone. So it says results that groups are not wiser, and in fact they could even be worse than a sole arbitrator. And it is worth noting that confirmation bias and motivated reasoning occurs at an individual level, but also at a group level. And in fact, if we take the task of judging, this is conducive to a biased information sampling of information, if not control, because interpreting law is not a task for which you have a demonstrable correct answer. It's not a pure science, but in fact it's a social science. And so this leads adjudicator basically to be consensus seeking instead of truth seeking when they interact with each other. And so we can see how confirmation bias will occur as a group phenomenon, because the interaction, the discussion will be more preference-driven to achieve this consensus instead of information-driven. So that's why we also have the need to have, there is the need to have some heterogeneity in the views of arbitrators to begin with. So then the same here, this biased information processing in group has been found to happen with conditions of time pressure, the need to justify the decision to other, and having a certain level of commitment for the group decision, and being some confidence and the confidence is in fact high in a group setting, because others will basically support your decision. So, and the same drawbacks will happen here. So basically, the outcome will be dependent on the members' initial preferences, and then we will have overconfidence and an illusion of validity. So to come back to the investment court, so we could say that as it has been witnessed in judicial settings, especially in the US, the investment court, if we don't attend to these behavioral influences, they could equally be subjective to this strategy. So now what can we do about them? And this is the last part of my paper. What can we do? So first, as a caveat, we have to admit that there are some characteristics of the legal system that we cannot change. It will always be a judgmental task for which there exists no demonstrable correct answer. There will always be a duty to adjudicate within certain time, and also just need to provide reasons for your decision. And we have also to acknowledge that yes, the investment court, as it's currently discussed, would address some of the criticism against international arbitration, but we can do more. And how can we do more? So we have to work on the selection of the member to ensure heterogeneity, and also how to design procedural rules that basically promote the careful consideration of all information. We also have to manipulate the members' motivation. They have to be accuracy motivated so that they are really driven by the need to make a correct decision. And we could also teach appropriate decision-making procedures to international arbitrators. So, and then that leads me to the conclusion of the paper, that basically institutionalizing ISDS will just transfer some of the defects that we are already witnessing in other settings, and that, but still we can do something since these influences are not absolute, and that it is, but for now it is doubtful this opportunity has been taken, since if we consider, for example, the investment court system currently in the EU, the new generation of EU agreements. And then, as I said, this is not really surprising, since behavioral considerations are not the primary concerns of institutional designers. So thank you very much.
Myriam, thank you very much for that introduction. Now, as I understand your argument, you accept that the current reform proposals do address some of the major criticisms that have been raised in the kind of the backlash against ISDS. But your argument is that to make the system better, we should also be taking into account behavioral influences. Policymakers should be taking into account behavioral influences and insights gained from psychology. But how far can we really go with this? I mean, isn't it right that any system of adjudication is going to incorporate these inherent issues? How far can policymakers actually go? Is it possible to create a perfect system of adjudication?
So thank you. So there wouldn't be a perfect system, because we cannot completely eliminate behavioral influences from how we make decisions, since oftentimes they are in fact unconscious. We don't even know they are happening. It's just the way our brains work. So instead of making the system perfect, we will just basically take some targeted intervention just to make it better. So, for instance, you have a number of methods, of rational choice methods, of step-by-step analysis of how to make decision. And so, if you could just transpose some of these settings in the new investment court. And for example, when it comes to procedural rules, so you have the Delphi methods that was advocated by Cass Sunstein and Reed Asti, which basically says that in order to get rid of social influences and status differences within a group, you basically make a decision. You basically make a decision following 3 steps. So first, everyone would give their opinion, but no one would know whose opinion it is in the first place, so you would have anonymity. And then people would give feedback on the different views of the members, and then because of this increased deliberation, then you wouldn't have the initial problem of what is my preference and or status differential between people, which sometimes lead to self-censorship. And then once everyone has nicely deliberated, attended to more information that they would have had without a controlled deliberation, then you have a more complete and more rational judgment. So not having the perfect forum, because we can't dismiss our natural processes on how we make decisions, but instead it's how to make it better, because we can do something about it. It's just that we have to take appropriate steps to consider it. Yeah.
Thank you. Simon, I understand that you're particularly interested in behavioural issues, how they affect decision making. Do you have some comments to make on Myriam's?
Actually, Andrew and I discussed, and he's gonna be asking that question.
Okay.
Thanks, Simon, and thanks, Myriam, for a wonderful presentation. I did want to, and you sort of anticipated my question in talking about the Delphi method, which I was very interested to hear about. But I was wondering if you could say more about what, accepting that human psychology will sort of necessarily play some role. What other procedural techniques or procedural rules specifically might be implemented to control some of these other selection biases aside from the Delphi method?
Yes, exactly. I didn't go into much details on the three avenues that I propose to system better. Basically, we should promote optimal and rational thinking by teaching non-faulty and rational decision-making procedures. So we have countless models for our rational choice models on how we should make a decision. So if we take, for example, Janice and Mann remedies to groupthink, that we have to consider all alternatives, and we have to go through all objectives, and so on and so forth. If we make decision makers basically aware of the different steps they should take to make decisions, then that will help. Although teaching rational choice theories to decision maker is not a solution on its own. So that I also consider a second avenue to change basically the motivation of an arbitrator. So for example, we have to make them accuracy motivated instead of personally or socially motivated. And so how we could do that in a permanent court would be like by making accountability for their decision very important. And so try to instigate some fear of invalidity of reprimand, which is basically currently missing with ISDS as we know it, because basically the tribunal, after giving the award, will just dissolve. And then, yes, we have challenges against decision maker and against the outcome, but these are very limited. It's not like with a permanent court. Basically, if you have an appeal mechanism, then you instigate that this fear of invalidity, that you have this risk that your decision would be basically overturned if you are not being very careful. But then when it comes to procedural rules, which was the third avenue for reform, so if I take the words of one psychologist, he basically said that we have to maximize the effective participation of all group members to ensure the greatest exposures of relevant ideas and information. And so all these procedural rules would basically mainly tackle how you conduct deliberation. So I mentioned the Delphi method, but another very important point, and in fact, if we take the EU-Vietnam agreement as an example, they are basically saying that they favor a consensual decision over a majority or another type of decision. And so this emphasis on consensus is in fact quite problematic because, as I've demonstrated earlier with the social perspective, if you focus on reaching a consensus, then you basically limit the amount of information that you are going to discuss, because you have to reach consensus at all costs, and so you favor self-censorship. So one way would be basically to promote a majority decision instead, or just do not say anything about, well, we really have to have consensus in adjudication, because this has some problems here. So another tool that Sunstein and Asti also mentioned, in addition to the Delphi method, would be to promote and to prime critical thinking. So having members really think about like challenging their own thoughts and not running to their preferences as confirmation bias usually leads us to. And then also and then the last area for the last tool was also basically to promote leadership, but inquisitive leadership. So having a leader, president of the tribunal, for example, being very supportive and trying to really engage the minority or his co-arbitrator, co-members, so that we have a nice deliberating setting. So these are the different tools that could be used basically to ensure a rational, more optimal decision.
This is such a fascinating discussion. It's such an innovative approach to looking at this issue. And I think we could go on and discuss this for another half an hour, another hour, just this topic alone. But I think we need to move on to the other topics on the panel now. Hopefully, we'll come back to some of these issues at the end if any members of the public have some burning questions. Okay, so let's move on now to Dr. Olmedo, who's going to introduce the second topic, which is whether we really need to tear up the system and do something much more radical.
Thank you. I have to say at the outset, I don't have an answer to that question yet, and I hope that you'll shed some light into it. Thank you so much, Nick, for agreeing to moderate. You have been doing a fantastic job so far, and thank you, organizers, for the invitation. And so, as Nick mentioned, in my paper, I discuss the potential of intrastate, state-to-state arbitration as not as a replacement, but as an alternative, in parallel, perhaps, to ISDS. And I mean, not a long time ago, investment disputes were resolved through diplomatic protection means, and I think most of us know that. And so this was an intrastate procedure. It still is an intrastate procedure whereby the state or nationality of the investor will bring a claim against another state for breaches caused to the investor or their investments. But with the proliferation of investment treaties and ISDS, the role of diplomatic protection has somewhat faded. And the main justification for allowing investors to initiate dispute against state directly under investment treaties was precisely that. And that was also mentioned by Nick at the beginning in introduction, was to remove investment dispute from the realm of diplomacy. But as also Nick mentioned in the introduction, we are now facing, so this depoliticization of investment dispute through ISDS is facing a legitimacy crisis. There are concerns that have been raised about the functioning of ISDS and investment treaties more generally, cost and length of proceedings, independence and impartiality of arbitrators, transparency, and inconsistent arbitral decisions. So there have been some reforms that are taking place. There is the reform process that is ongoing where states are amending their treaties. And some of them are finding alternatives to ISDS. They are not very happy with the fact that investors can bring direct claims against tribunals. And they have decided to replace ISDS state-to-state dispute resolution mechanisms. And And one example, a good example of those states that have replaced ISDS with state-to-state arbitration is the United States and Canada, and under the United States, Mexico, United States and Mexico under the United States, Mexico, and Canada agreements. And so this raises the question, is it a good idea to go back to diplomatic protection, to repoliticize, if you will, investment disputes? And this is the question I'm attempting to address in the paper. I don't have an answer to that yet, but hopefully after today's presentation, I will have a clear idea of where I want to go with the paper. So before, so in my paper, I discussed three main issues. The first is, I mean, is it viable? Is it possible? What is the scope of a state-to-state arbitration provision? And the second is, what is the law that applies? And if it is a state bringing a claim against against another state, not the investor directly. And the third issue I discuss in my paper is, do state-to-state arbitration provisions, do they actually address concerns that are now currently, I mean, that we have in ISDS? And I don't have time, of course, to discuss all these issues. So the first question, the question the issue I wanted to discuss today is, what is the law that will apply in state-to-state arbitration disputes? And is a customary international law? I mean, of course, the treaty, the BIT, would be one of the sources that should apply, but I mean, should we go beyond that? Should the tribunal also apply customary international law? But before that, I would like to make one important observation, and that is that, as I mentioned, yes, there are states that are replacing ISDS with state-to-state arbitration provisions, but still today, most investment treaties, they contain ISDS provisions, and most cases are brought under these provisions. But we cannot forget that most BITs, if not all, they contain a parallel state-to-state arbitration provision. And the fact that they are not used in practice doesn't mean that they are not there. And so the question that arises, I mean, what is the scope? What is the viability of those provisions? And there is only one case where a state brought an arbitration against another state by using or invoking those arbitration provision, and that is the Cuba-Italy via arbitration that was initiated by Italy on behalf of 17 investors, Italian investors under the Cuba-Italy BIT. And there all these questions arose. It was the first time, unless public knowledge is concerned, that these questions that I'm raising were answered by that tribunal. So we only have that case unless someone else knows of another case. And then the first question the tribunal determined was, is it possible? I mean, this parallel existence of ISDS and state-to-state arbitration, does that mean that a state can decide to bring a claim on behalf of a diplomatic protection claim on behalf of an investor, even though the same treaty, like the Cuba-Italy BIT, contains an ISDS provision? The answer was yes. If the investor has not initiated an arbitration with regard to the same dispute, I don't see, the tribunal didn't see a problem there. Yes, you can initiate a state-to-state arbitration provision dispute. And the second question, which is the issue I wanted to address today, unless I want to bring up some of the main points that I'm examining in my paper, is what law applies there. Because as you know, as you may know, in diplomatic protection, you have two sets of rules that are applicable. One is nationality, rules on nationality, and the other one is exhaustive local remedies. And most ISDS tribunals, well, in most cases where there is a question on nationality, states, they have argued, ISDS cases, states, they have argued, well, we want to import the rules of diplomatic protection on nationality because they are much more restrictive than the rules on nationality that we see in BITs. And most tribunals have rejected that argument under the premise that BITs are lex specialis and therefore exclude customary international law diplomatic protection. And that question was before that tribunal, the Cuba-Italy tribunal. But this time the tribunal was not an ISDS tribunal, was a tribunal constituted under a state-to-state arbitration provision. But again, we are before a BIT. So Italy brought a jurisdictional objection arguing the jurisdiction should be denied because the investor is a shareholder of a company that is operating in the host state, and therefore it shouldn't be entitled to claim, because under diplomatic protection, shareholders are not, the state of the shareholder, sorry, in this case, Italy, are not entitled to bring a diplomatic protection claim. The tribunal agreed with the arguments brought by Italy, and it declined jurisdiction because the investors were shareholders of the two companies investing in the host state. That will never happen in an ISDS claim, because again, tribunals tend to view BATs as an instrument that applies in isolation from diplomatic protection. And the other question for the tribunal, the other argument that was brought by Italy was, okay, the investor didn't exhaust local remedies, another rule that applies in diplomatic protection. And it brought a jurisdictional objection saying the investor should have exhausted local remedies, therefore the investor didn't, there is no jurisdiction. And the tribunal agreed also with that argument by Italy and declined jurisdiction on those bases as well. So, and I don't know how much time I have left. Sorry, I was 2 minutes. Okay, I'm almost done. So I think this is a very important question, because now treaties like the United States, Mexico, and Canada, they contain state-to-state arbitration provision as a replacement of ISDS. So there we don't have a parallel, we don't have an option. In investors there with respect to investing in Canada, they don't have in Mexico, they don't have an option. They cannot access ISDS. They have arbitration provision, provisions, and the question is gonna be raised in those cases. The state will probably invoke customary international law and the more restrictive rules of diplomatic protection, and the question will be for the tribunal to decide: do we follow the approach that was adopted in the Cuba-Italy arbitration? Do we incorporate the rules of diplomatic protection or not? And if they do, a very large amount of investors will be excluded from BAT protection, because most investors that bring claims are shareholders and not companies incorporated in the host in the host state. So that is for me a question that needs to be answered, and I have a view on it, but I don't have the time to answer it now, and so I would like to leave it there.
Thank you, Javier. So now, as I understand it, what you're arguing is that that the rules of diplomatic protection, including the rules on exhaustion of local remedies and the nationality rules, should basically be incorporated and should apply irrespective of who the claimant is, and should apply therefore to ISDS claims as well. So I'd like you to just elaborate a little bit more on that, to explain the justification of that.
Okay,
but before you do that, it'd be helpful as well just to explain what I think your argument is also predicated on the fact that you think that the incorporation of these rules of diplomatic protection, including the exhaustion of local remedies rules, is a good thing for the system, will improve the system, would reform the system. So it'd be helpful also to understand why as well you think that these are positive things.
Okay, let me answer that first question. I'm not arguing, not now, not in this paper, probably in other papers, but now I'm not arguing that incorporating the rules of diplomatic protection is a good thing. Okay. And we can see, in this reform process, we can see more and more that states that are incorporating customary international law rules on diplomatic protection, and one of these rules is the dominant and effective nationality rule, which applies in cases of dual nationals. And so you can see more and more treaties incorporating this rule that is not found in most BATs. And the same with respect to other rules of diplomatic protection. In this case, those that apply to corporations, like the substantive business requirements that you have in Article 9 of the draft articles on diplomatic protection. And you can see more and more BATs containing those rules. I mean, whether that is a good thing or not, I mean, that is a question for the state to determine, and depending on their policy. But and then with respect to, but nevertheless, I think the question is still there. Whether or not it's a good idea, I don't know. I mean, that is a question that we have to also address. But irrespective of that question, the question can be posed before the tribunal, which, I mean, should I apply these more restrictive rules? And it's a valid argument for the state to say, well, we have this arbitration cubate, there's only one, but why would you apply? And this goes to this is gonna answer to your first question. Why? I mean, what is the policy justification or the legal justification to not apply customary international law in ISDS claims because the investor is the claimant in the dispute, but apply those rules in intrastate arbitration procedures where the same instrument is being applied under the same instrument, the same BIT? Why that distinction? And there we come to the question that, well, the Mallet-Prevost formula, that the argument is, and Douglas has made this argument in his treatise on investment claims, that in diplomatic protection, the rights that are considered are the rights of the state, not the rights of the investor, and that is different to the situation in ISDS, where the investor has been granted direct rights, both procedural and substantive. So that is the justification we have been using for a long time, tribunals as well. And an example of that is a case I was involved on a case precisely of dual nationality. And there the tribunal made the arguments. This is a BIT, ISDS, BIT, the right invoked or rights of the investor. This is not diplomatic protection. This is not customary international law. We should not incorporate customary international law. But still, the tribunal didn't really revelate there. It just used the argument that we have been invoking for a long time. But I just don't see legally, under rules of international law or treaty interpretation, why would we make a distinction? What is the legal architecture of investment treaties? I mean, should we apply different laws and rules depending on who is the claimant behind the claim? Is that what we're trying to? I mean, is that the purpose of BITs? And in my view, it's not. And there is no policy justification for it, or no legal one for that matter. If you apply customary international law, even by interpretation, we're leaving aside interpretation now for the moment. If you apply customary international law in intrastate arbitration disputes, I don't see the reason why not applying customary international law in ISDS disputes. But I'm going to leave it there. We can discuss on this later if you want.
Myriam, I think you have a burning question as well, or a burning comment to make on this.
Yes, so in your introduction, you mentioned that your paper ends with the question whether state-to-state dispute settlement would solve some of the concern raised by ISDS. So would it? Or if not, what could we do for a state-to-state dispute settlement to solve some of the concerns of ISDS?
Well, I'm working on that. But I mean, the question there is, are we going to be, I mean, are intrastate arbitration provisions raise the same concerns that ISDS? And I mean, if we now are in a world where ISDS, we can imagine for a moment, assume that ISDS is non-existent from tomorrow, and then we only have intrastate arbitration mechanisms, are we going to be in 10 years' time in the same situation? I don't know. What I can tell you now is that if we want to have a system, or if a state plays ISDS with intrastate arbitration provisions, I think that they should consider addressing these concerns that we have in ISDS, because they may be similar concerns may arise in intrastate arbitration disputes, and one of them is inconsistent decision, for example. If you see the BITs today that contain only intrastate arbitration provisions, they don't have complementary, let's say, mechanism to avoid inconsistent interpretations like other treaties have. And so that is, for me, for example, one aspect of how the type of provisions or solutions that should come with this type of provisions. And another one is, what do we do with the award in terms of, I mean, to whom the proceeds should go, damages. In diplomatic protection, the proceeds go to the state that initiated or exposed the claim. In ISDS, goes to the investor, but we don't know if now we have a claim under a BIT, like in the Cuba-Italy arbitration, should damages be paid to the investor directly, or should we adopt the approach that we have in diplomatic protection? For me, in terms of procedural efficiency, I would say, or policy even, the damages should go to the investor, not to the state. But this is another issue that arises. So we should also think about that, or states should think about this if they want to replace ISDS with intrastate arbitration proceedings, because the question is going to arise. And the same goes to cost and length of proceedings. I think it's another the problem that may arise in intrastate arbitration disputes. And so, yeah, I think that we states should be thinking about, well, if we want to replace ISDS with these provisions, these amendments should come with provisions that prevent or foresee potential problems that we now have in ISDS. Sorry.
Okay, we've got some interesting questions come in from the audience. I think we should address them now while we're still on this topic. So the first one is from Ladan Meremba. He's asking about the Ecuador-US arbitration, a 2012 decision. I'm not sure if you're aware of that decision.
Yeah.
In which Ecuador wanted a clarification of an interpretation of a treaty provision, but the tribunal held that they had no jurisdiction because they said that there was no dispute.
Yeah.
I mean, is this an issue with the kind of the proposal that you're thinking about, the use of state-to-state arbitration? Is there a risk that tribunals will largely say, well, no, we're not gonna issue awards on theoretical issues unless there is a dispute?
Yeah.
And for there to be a dispute, the other treaty partner has to actually, raise a dispute.
And it's a good question, yes, but there are two different. I mean, what intrastate arbitration mechanisms in BATs, they have different purposes. One of them is interpretation, and well, they can lead to interpretative agreements. They're called. How do the state want to consider a provision should be interpreted? That was the question that was raised in that case. And I mean, if the question is if I agree with the decision, no. And it was in my view, it wasn't really. The reasoning of the tribunal was not very comprehensive in that respect. The tribunal just held that, okay, there is no dispute because the other state is not participating in the process. And whether that will happen, and in a intrastate arbitration where we have a diplomatic protection claim, not a dispute in relation to the interpretation of a provision, I really doubt it, because there we have a dispute. So this is not two states coming to an agreement as to how a provision should be interpreted. This is an investor that has an expropriated asking their state or nationality to bring a claim on his behalf. So we have, I would say we have, I mean, I would really find it difficult, especially in a situation where there is no ISDS, because I think in this case, we already had an award that was rendered in the Ecuador case. But if we only have an intrastate arbitration provision, we don't have ISDS, the investor hasn't initiated an ISDS proceeding. I really doubt that a tribunal would not want to continue with the process, because then the investor will have no other option. I mean, it will leave an investor without protection if we don't go. If the tribunal doesn't initiate doesn't consider that it's a dispute because the other state is not still involved in the process. And so that will be my answer. I think there is another one, no?
There is, but I'm afraid we're running out of time as ever with these panels. Unfortunately, we don't have the time to discuss things in over amount of depth. But we will try to come back to the next question at the end of the third topic if we still have time. So thanks again for the question, and we'll try to pick that up at the end when we sort of round up in our discussion. But that just leaves me then to hand over the floor to Simon and Andrew to take us into our third topic, which is this interesting issue of silence in investment treaties.
Thank you, Nick. And thanks to the SIEL organizers. It's a pleasure to be here. So I'll give an overview of the article, and then Andrew will highlight some specific points we addressed in there. So the idea for the article came from our practice as counsel in investment treaty disputes. We kept seeing arguments made by both claimants and respondents based on the silence of the treaty on a given issue. Claimant typically said the treaty does not expressly preclude this, therefore it's covered by the treaty. And respondent took the opposite position, saying the treaty does not expressly permit this, therefore it is not covered by the treaty. So we saw this dynamic at play on many issues of jurisdiction, such as consent to arbitration for mass claims, claims of dual nationals, coverage of indirect investments, shareholder reflective loss claims, denial of benefits provisions. There are also arguments based on silence on issues relating to the merits. For example, the claimant would argue that the treaty is silent on the standard of compensation for unlawful expropriations, and therefore a standard of compensation other than the one specified in the treaty should apply to such expropriations. Faced with such arguments, tribunals have rendered many decisions in which they attribute meaning to treaty silence. Tribunals have followed three main approaches, which we refer to as creative, restrained, and systemic. Tribunals following the quote-unquote creative approach consider that what's not expressly prohibited is covered by the treaty. Tribunals following the restrained approach consider that what is not expressly permitted is not covered. And tribunals applying the systemic approach, the third one, rely on relevant rules of international law to fill in areas of silence. We show that the creative approach, the first one, has been predominant in investment treaty arbitration. In other words, tribunals tend to interpret silence expensively to mean that what is not expressly precluded is covered. The treaty is silent on mass claims are permitted. The treaty is silent on coverage of indirect investments are covered. The treaty is silent on coverage of tax matters, you'll be familiar with that one, Nick. Tax matters are included, even though they are considered highly specialized matters that are the subject of a dense network of tax treaties. We argue in the paper that there's a tension between the creative approach to silence and at least three basic principles of international law. The first one is the principle that jurisdiction does not exist in international law unless it is expressly confirmed. That would seem to militate in favor of a more restrained approach to jurisdiction. The second principle is that a state normally is not bound by any obligation under international law unless it has expressly consented to that obligation. That principle has exceptions and its application is not always straightforward, but it would also seem to invite caution in delimiting the scope of states' obligations. The third principle is that a treaty must normally be interpreted not in a vacuum, but in light of background norms of international law. So even if the treaty is silent on a given issue, for example, Javier is a specialist on this issue of dual nationals, that is not necessarily the end of the analysis. The tribunal has to look at relevant norms before reaching its conclusion. In the final part of the analysis, we discuss ongoing reform efforts and whether they may have an impact on those dynamics, but we conclude that this is far from certain. We say that even if the ongoing reform attempts succeed, it's likely that the current trend toward creative interpretations will continue. So I'll let Andrew get into some of the specifics of the article. Thanks.
And thanks, Simon. So I'll go into a few of the examples that we talk about in arguing that the creative approach has been the predominant approach to silence in investment arbitration. And one of the best examples, as Simon suggested, concerns mass claims. So we start with the Arbitral case, where hundreds of thousands of holders of defaulted Argentine government bonds decided to bring a single treaty arbitration. And in that case, it was common ground that neither the ICSID Convention nor the Italy-Argentina BIT said anything about a mass claim like this. And the tribunal recognized in principle that this silence could be a limitation. But instead, it decided that since bonds were a protected investment under the treaty, they would be better protected, they would receive more effective remedies if they could proceed through a mass claim. So for the tribunal, this meant that the spirit of ICSID and the purpose of the BIT should provide coverage of mass claims to promote effective remedies, and nothing in the treaty said that those remedies weren't available. So that's the heart of the creative approach. Nothing in the treaty says we can't do this, and we think it would help investors if we did it. Arbitral is a striking example. A framework for mass claims does not exist in the ICSID Convention. That was common ground in that case. But the reasoning underlying that decision exists in a lot of other areas. So Simon also alluded to dual nationality, which we look at, where there's a well-known rule of customary international law establishing that dual nationals generally can't sue their own state on the international plane unless it is not their state of dominant and effective nationality. Now, the full chamber of the Iran-US Claims Tribunal recognized this rule. It relied on Article 31.3c of the Vienna Convention, which provides for interpreting treaties in light of relevant rules of international law applicable between the parties, to read this prohibition into the silence of the Algiers Declaration. Now, investment treaty arbitration hasn't clearly broken away from that approach, but there is a split in the cases. And what we think is remarkable is that you have decisions like Pay Casado, where tribunals look at what they expressly characterize as the silence of treaties, look at this background where bodies like the Iran-US Claims Tribunal have read a customary prohibition into that silence, and they've said nothing in this treaty prohibits claims by dual nationals. Nothing in this treaty says that I can't exercise jurisdiction. As Simon mentioned, we do think that this approach has played a key role in defining international investment law, and we think that there are a lot of problems with it. The biggest problem is that this isn't how drafting works. Whether you're writing a treaty or anything else, you ordinarily aren't saying everything that you don't mean. And as Simon mentioned, this is particularly important in international law, where there's no default forum, where jurisdiction requires state consent. So we're not saying that it should be impossible to premise jurisdiction on an inference, but we would probably say that doing so should be exceptional, and the inference should be very clearly derived from the text. And that's not what we're seeing, including on some issues that people consider to be settled questions in international investment law. The other major problem with the creative approach is that it creates needless legal conflict. So we recognize that background legal norms aren't always better, and that the reason you sign a treaty isn't because you're necessarily happy with the law as it is, but because you want to create special rules for certain situations. But that's not really the issue. The issue is that, like almost every legal instrument, investment treaties are not self-contained, and they have to be read in light of other rules of law. And that's what the Vienna Convention itself provides. And what we see with the creative approach is what sometimes seems like an almost willful blindness to aspects of international law and to aspects of corporate law and regulatory law that there may be a renvoi to in relevant international law, where treaty silence is read as a derogation from a background rule. It's almost this idea that you have to contract into laws that you're not departing from, as opposed to expressly departing from laws that you're not applying. We think that that's the wrong approach. We think that ordinarily different systems of law should be read in harmony where it's reasonable to do so. And we do think that silence is generally a situation where it's reasonable to do so. There are other examples that we discuss in the paper. I won't go into all of them now. I'll also say that we are hoping to do more comparative work and focus on the example of the WTO, both as an example of how judicialization won't necessarily solve perceived problems with interpretations of silence, and just to take other examples of interpretations of silence. But I'll leave off with that for now. And thanks, Nick, and everyone. I think you're on, Nick, you're on mute.
So first of all, a comment, and secondly, a question. Again, very interesting paper. Obviously touches upon some issues that we have faced on the other side. I mean, first the comment, the term creative approach. Now, to me, it seems a loaded term, a loaded and provocative term, and maybe that's intentional. Do you mean an expansive approach? Is that the same? Is expansive? You talk about a restrictive approach. Is the creative approach really just an expansive approach, or are you really intentional in your designation of the creative? I don't know if that's just a comment. I don't know whether you want to.
I think it's maybe a nice way to say it.
And then a question. The broader conference, as I mentioned, has been about rethinking and recalibrating and redesigning international investment law. And we talked about some of the reform processes. It'd be helpful for me to understand how you think, how do you think the current reform processes are addressing this issue of what you mean this issue of silence, and are they addressing it? Can they address it?
Right. So maybe I can touch upon that. So there's two main categories of reform efforts, as we know. One focusing on the substance of treaty norms, and one focusing on investor-state dispute settlement. So substantive reform often comes up when dealing with how to address expensive or creative interpretations by tribunals. So the reasoning is simple. If states are not happy with tribunal interpretations, they should simply fix their treaties. This may be appealing on the surface, but we think it's a bit simplistic. First, it may be feasible to amend treaties in reaction to existing interpretive trends. But one cannot anticipate and fill in all conceivable areas of silence. There's that challenge. Claimant and tribunals have identified areas of silence, even when the treaty contained text that seem to address expressly a particular issue. For example, in the case of denial of benefits clauses. So insisting on treaty drafting as the key solution results in placing the burden on states to anticipate and address in advance potential areas of silence that may not be easy to identify beforehand. We also think that the treaty drafting sort of paradigm or option is not always realistic, because it's not easy to amend treaties, even when states agree on the substance of the issues. That's because states perceive that restricting the coverage of their investment treaties will send negative signals to global markets, for better or worse, and that they'll damage their brands, so to speak, as investment-friendly jurisdictions. So one can't assume that states are happy with expensive interpretations just because they haven't amended their treaties. It's more complex than that. So on the ISDS side of things, so the main example, of course, is the discussion at Ancestral Working Group 3, potential adoption of a multilateral investment court, or at least an appellate mechanism. So those discussions seem to come closer to the issue as they attempt to change the incentives and control mechanisms for ISDS adjudicators. But as several authors have pointed out, simply reforming ISDS without fixing the substance of the norms actually risks entrenching, that's the word that keeps coming back, current interpretations and approaches rather than achieving change. So in our view, treaty drafting and ISDS reform, especially if conducted in isolation, will not solve the problem. Even approaches that combine both, for example, Myriam mentioned the Vietnam treaty with the EU. There's also the EU-Canada CETA that address both substantive norms and ISDS. In an ideal world, you'll find that the amended norms and the court system contained in those kinds of treaties may result in recalibrating the adjudicator's interpretation. But this would have limited effect in any event, because it is just one treaty or a few treaties among thousands that continue to be old school bare bones BITs, as we refer to them. And there's actually a whole industry revolving around nationality planning, an industry of lawyers I'm talking about, to structure investments to take advantage of those kinds of BITs. So our view is that systemic reform of both the substantive norms and ISDS at a global level would be necessary to effectively address this question. I appreciate that that's not very realistic, at least in the current environment, where reform efforts are limited, piecemeal, and fragmented geographically. Thanks, Nick.
Now, I think Javier has a burning question, but before we address that, just because there are some nice questions coming from the audience, let's pick those up first of all. So there's two questions, one from Afifan King and one from Wojciech Giemsa, which I think basically run together, and they are, one, to what extent you've done a comparative review, but to what extent is this problem of silence and the reaction of that problem of silence, is it specifically found in investment treaty arbitration, or is it a problem that is arises and is dealt with in a similar way, within the jurisprudence of other international treaties. And then as a kind of corollary to that is, and I think this is coming to my point about the creative approach. Are you suggesting that arbitrators are taking this creative approach in terms of a pro-investor and pro-investor bias? Because I think there's some suggestion in your paper that this is kind of claimants and their clever arbitration counsel coming up with arguments as to why things could be that don't exist in the treaty. So again, if you could just have a quick comment on that.
Andrew, you want to take that one?
Sure, yeah. I'll start with Afewan's question. I think we've started to do a comparative analysis. We don't have something comprehensive. I think we do think that, particularly as this pertains to jurisdictional issues where a lot of our examples come from, this does seem fairly distinctive, the creative approach. I mean, obviously there are other international tribunals where there are expansive readings, broadly conceived. And I don't want to say that we've exhausted the comparative analysis with respect to those, but I do think our tentative view is that there is something distinctive going on here in this sort of recurrent jurisdictional controversies over a number of issues where there's a departure from background, customary international legal norms or background restrictions on the presumption of jurisdiction that, seem to sort of consistently be tossed aside. And then as to whether this is about pro-investor bias, I do think that's sort of, where we're coming out, and maybe that bears on the point of the, whether creative is the right word or we should just be saying expansive. But I do think that what we're trying to do is more than just say, respondents are losing arguments that they should be winning, or claimants are winning arguments that they should be losing. I think we are trying to look at, what is this interpretive tendency? What is this reasoning when faced with a particular problem? How is it consistent across different issue areas in investment arbitration? And what problems does it pose for the investor-state arbitration system? I mean, a lot of what I talked about were these sort of conflicting, unnecessary conflicts with other legal regimes. And one area that I didn't get into, but where I think you see this a lot, is reflective loss claims, where you have what arbitrators have considered to be a silent departure from a rule of advanced corporate law that, according to the OECD, is uniform in advanced corporate law systems, and that's been reaffirmed as applicable in international law twice by the International Court of Justice. And what you can sort of predict, and what you're starting to see a little bit in follow-on litigation following an investment treaty award, is litigation between interested parties in a corporate family or creditors over distributions of awards, because arbitral tribunals are sort of needlessly creating, disrupting these sort of basic principles of the corporate form that are important not just for corporate law, but for securitization and bankruptcy and lots of other fields. And so, we think that conflict is itself fairly significant. I hope that answers some of the questions.
We've in fact had another series of questions, I think quite interestingly addressing, possible options to dealing with this problem of sidecar. And one suggestion comes in from Ladan Merenbar, which is the possibility of to some extent obligating home state to provide interpretations on particular treaty provisions. And obviously, Greg Koropowski has come in and referred to the NAFTA example of the Free Trade Commission's notes of interpretation. I mean, what do you think about that as a possible solution?
I think it's, if I can take that one, Andrew, that sounds quite difficult, this concept of obligating a state to submit a position in a proceeding. I don't think it may have been, it's a very good question from Leighton. I suspect it's a bit provocative in spirit. And I think it's just not very feasible. I mean, there are several questions why a state may not want to submit a non-disputing party submission. I mean, first of all, I mean, many times you have an organizational issue, right? You know, how do we come up with there's an ongoing dispute. You're not always dealing with very organized states. There's an ongoing dispute. How do we create a process through which we're going to identify the state's view on a particular treaty interpretation? On some issues, actually, you know, there may not actually be a position there that can be easily discerned. And then we come back to this other issue which I've flagged before, which is what signal does this send to the world, right? If you're the home state and and this is why you can't obligate, I think, the state to do that. If the state perceives that it's not in its interest to send a quote-unquote negative signal to the world about friendliness of its investment environment, you know, you can do it. I don't necessarily believe that that's the case, but there's a lot of actually lobbying in states to make them believe that. Sometimes that can be a real effect. What's interesting is that in connection with that, you see actually developed states doing this quite a bit. I mean, the US, Canada tend to intervene quite a bit as non-disputing parties, not just in the NAFTA context, but even in the BIT context. I've seen that happen many times. The EU also intervenes quite a bit, especially on this CMEA issue. And so you have a lot of these, but let's keep in mind that these states are this category of developed states that have a very sophisticated policy discussion about what they want to do with their investment treaties. It's not always easy to do that for the rest of the world, let's put it this way. And with respect to the two notes of interpretation, I mean, it's of course it's let's say a tool in the toolkit for states to do this, but a bit for the same reasons that it's not easy to amend treaties. It's not easy to reach agreement on these kinds of notes, and you don't see a lot of agreements like this. I mean, you see states trying to do that. For example, India has famously put out a draft interpretive statement and proposed it to a lot of its treaty partners, and it hasn't been very successful. I think it's reached agreement on just a couple of times. So you can try, but you may not succeed.
Let's give the last word to Javier. I think he had a burning question.
Yeah, well, I have now many questions, but I know we don't have much time. We can discuss that. We can discuss it later. So, when I listened to your presentation, when I read your paper, I'm correct if I'm wrong, but I feel that there are two different questions that arise with respect to the creative approach. One is how to determine silence, and the other is how silence should be interpreted. And I was wondering if in your paper, I mean, if you combine these two, separate them, or maybe you don't think there are two different questions there. And I was wondering if you touch upon that.
Yeah, I think I'll take this one, if that's all right. It's a great question, Javier, and I think when we started out, we do focus in the paper more on how do arbitrators respond to instances of silence that they've identified. And I think when we started out, we thought we were going to focus more on, what does it mean for a treaty to be silent? Is this treaty silent or not? And we moved away from that mostly, not entirely, and I'll get back to the few points where we discussed that, but we moved away from that because what we thought was really interesting and what we started seeing in the cases was these responses to where arbitrators identified silence. So Abaclat is a great example. In Abaclat, everybody said the treaty's silent, what do you do with it?
Yeah.
And so that was sort of why we started focusing on the responses. And once we did that, it was easiest to say, how do you respond in a situation where you, the arbitrator, identified silence, as opposed to say, coming up with our own criteria for whether a treaty was really silent or not, and then sort of rereading the cases against that lens. So that's the answer. It focuses more on silence identified by arbitrators in order to in order to most cleanly analyze the responses.
But
Sorry.
if I can just, because I know I can see Nick, but if I can just briefly comment on that. And I mean, in dual nationality, for example, and one of the arguments that was made in the Garcia Armas arbitration and was, well, yes, the BIT doesn't expressly exclude, it doesn't say dual nationality, but it contains an exit provision. And we made the argument that has been followed by other tribunals, which is very interesting. So if you have an exit, even though it is an ancestral arbitration, obviously the investor knew, I mean, he knew what he was doing. But if we have an ancestral arbitration, but still we have an exit arbitration clause, that's what I mean by determining silence. I mean, does that mean that the treaty is silent in dual nationality? So I think it would be interesting. I mean, you can. It's up to you to discuss that. But it would be very interesting to if you develop that argument, that idea a bit further, because on dual nationality, I'm saying, but maybe this issue comes up with other provisions as well. But there, and you can see tribunals picking that up in dual nationality. Yes, we have an exit provision, so it's not silent. So the state decided to. So you cannot decide whether you cannot base nationality requirements on the institution under which you are. You know, the rules under which you're bringing the arbitration, but on what the treaty says in substantively. So I think it's something interesting that you can, but we can discuss that later. We can be in touch on, yeah.
And of course, that's an interesting example of treaty silence being interpreted in a way that is not pro-investor. So it shows that, you know, tribunals don't always take a pro-investor approach. It's not simply tribunals, you know, creatively trying to get more work, and you know, there is sometimes a restrictive element to the so-called creative approach.
Oh, of course, and we're not suggesting that it's uniformly. You know, there's a lot of diversity in the jurisprudence. That's the trend we've identified. Of course, even on that particular issue, and Javier can speak about that better than me, but there's, you know, quite divergent decisions on this point. Decisions that say, you know, the argument that Javier made in that case is just crazy. I mean, this is not an exit case, it's an ancestral case. I'm not suggesting that myself, but some people are saying that, you know, that's the case. So there's also a lot of pushback on when you have instances of those kinds of interpretations being adopted, and you have also a different strand, of course, that, you know, we discussed in the paper.
But is that a good idea? Because I find that interesting. Yes, not all tribunals take the creative approach. But look at, again, the Spain Venezuela BIT, the same treaty being interpreted completely differently. Is that what we want? Isn't that one of the main concerns of investment arbitration, inconsistent decisions? So I don't know if it is a good thing that some tribunals say, yes, we adopt an expansive approach, and others say, no, we adopt a restrictive approach. I think uniformity, as Simon was saying, I think probably that's what we are trying to achieve. I don't know. Just a comment.
A very interesting comment as well come in from Wojciech Jemsa, really asking whether you've thought about the composition of who's making these decisions, and whether, you know, whether there is whether the creative approach is taken by PIL academics, or whether it tends to be more the sort of the commercial argument. I know this is a topic that Anthea Roberts is particularly interested in. You know, this analysis of the kind of the sociological analysis of arbitral tribunals and their decision making. I don't know whether you've correlated the creative approach to the. I suppose it's difficult where a tribunal is composed of three arbitrators.
We haven't done it, and we probably will not do it. I mean, we don't want to, you know, name names, put people on the spot, probably, you know, people will recognize themselves. But the point is, I think it's an excellent question, and there's definitely sort of a cultural or sociological component, you know, to all this, and it's not just limited to the PIL or commercial arbitration background. I mean, it's it goes with all the issues that are being discussed in the Ancestral Working Group 3 about the process, about the incentives of arbitrators, all of the sort of constraints that exist or do not exist on legal reasoning. Some of the things that Myriam was talking about. What are the is there an incentive toward accuracy or towards sort of intuitive justice or justice in favor of particular interest groups? You see a lot of that in actually certain arbitrators, decisional trends.
I mean, this has been a completely fascinating topic and a completely fascinating panel. And I think we could probably, the hour and a half has run away with us, and we could probably go on discussing these issues for some time. Now, I'd like to thank the audience for actively participating and raising lots of interesting questions and comments, and we've all really greatly appreciated. I think what we tried to do is try to move beyond the discussion about reform, which simply looks at the institutions and looks at what's being done within Unstral, what's being done within ICSID, and try to dig a little bit deeper in terms of some of the problems and some of the specific solutions that might be formulated to address that problem. I hope that we've started that discussion, started a sort of deeper analysis of the problems and the solutions. So it just leaves me to thank everyone that's participated today, all of the speakers, Myriam, Javier, Simon, and Andrew for putting in a lot of effort and putting in with lots of calls from me to organise and coordinate this panel, and then lastly, as I said, from the audience for actively participating and raising your questions and comments, which I think has probably been helpful for everyone in terms of sort of further formulating and refining their ideas. So thanks everyone, and enjoy the rest of your afternoon, and look forward to the other exciting panel.
Thank you, Nick.
Thanks, Nick, for excellent moderation.
Thank you, everyone. Thank you, Nick.
Thank you.